Yes, let us begin the new year with some positive note. Yes,
May I beg to mention item number 12?
your microphone is not working.
Voice is completely.
Actually, voice is low, your lordship.
Acha.
Good problem.
Yes,
I beg to mention item number 12.
item
There
number
is
2.
an idea, lordship. There are some factual error in the petition. So I want to withdraw the petition and with liberty to file a fresh. This is a delay condition application.
He wants to withdraw the IA, your lordship.
Is it permissible to withdraw an IA?
Some defect in the.
Are you? All right, Mr. J. Das, Learned Legal Aid Counsel, appearing for the applicant, submits that there is some defect in this IA which calls for rectification, and therefore he be permitted to withdraw the same with liberty to file a fresh. Full stop. Ms. B. Bhuya, Learned APP Assam, is present and does not have any objection if the prayer is allowed. In view of the above, the IA stands disposed of on withdrawal with liberty as prayed for.
Thank you,
Yes.
Your Lordship. Lordship, I beg to mention item number 12 and 39 of the hearing list, Lordship, may be taken up after 9th of January, Lordship, by senior is out of station. Lordship.
All right.
It may much obliged, Lordship.
But Lordship, just it's special hearing is item number 2, Lordship. If it's after Bihu vacation, Lordship.
Why?
PJ Mohan Sahil API, Lordship.
Who?
PJ Mohan Sahil, Lordship. Principal is Edinburgh Hospital. He regular and coming to the court, Lordship. So he come to after Bihu vacation, Lordship. Item
Alright.
2. Special list.
All right.
Obliged, Lordship.
Daily list for admission, item 1.
Lordship, in this matter, we are filing the affidavit in reply filed by the to the affidavit filed by the restaurant 6 today, Lordship. Lordship may take up the matter after a week, Lordship. Today, we
What is the matter?
Lordship, on 21/11/2021, the petitioner number 1 was picked up by the police of Panbaza police station. At that, while picking up, he was told that certain cases has been without naming any case number, Lordship, he was picked up. And thereafter, the restaurant number 6 came to the police station, and all the misbehavior, the petitioner number 1 was manhandled on that day. He was kept overnight in the Panbaza police station, Lordship. On the second day, on 22nd 11/2021, the petition number restaurant number 6 came there. Restaurant number 6 petitioned the petition number 2 to come to the police station with otherwise he has threatened that the petition number 1 will be sent to jail, and they were forcefully one agreement and affidavit was forcefully executed by the petition number 1 and 2. And thereafter in the evening they were released.
What is the agreement about?
Agreement, the petition number 6, so that he was supposed to get certain amount from the petition number 1. At that, at some point of time, they were business partners. There were some litigations, but the bank litigations are there, criminal litigations are also there, but all are settled, Lordship. Now, there were nothing to be recovered from the petition number 1, Lordship. And Lordship, assuming certain amounts were to be recovered, but this is not the way, Lordship. The way they have been picked up.
Where is the agreement?
Agreement we have annexed. Lordship. Agreement is at page 19, annexed to polygons.
Page 19.
19 of the petition. The agreement, Lordship, with page 21, Lordship will kindly see. There is a down below this, in the year 2016, the first party has availed a loan of 45 lakhs. But this 45 lakhs is in connection with a particular loan taken by the company of the petition number 1 and restaurant number 6, Lordship, and which is already settled with the bank, Lordship. And there was no such agreement at that point of time.
So what is the relief you want here?
Lordship, we at that particular point of time when the petition was filed, we wanted protection of the petition number 1 and 2 and their family. But Lordship, certain new facts have come in the affidavit filed by the restaurant number 6 now. The affidavit that has been executed on 21/11/2021 on that was shown to be notarized on 22/11/2021. But at that point of time,
No, no, Mr. Das,
Yes,
you
Lord.
see, this matter has been entertained as a writ petition
Yes, Lordship.
as a habeas corpus,
No, Lordship, is a police atrocities.
police atrocities. Now, your allegation is that in police station, your client was threatened and coerced and forced to
Yes,
sign an agreement
Yes.
at the instance of the respondent number
Yes.
6. So that incident is over and your client is already released on that
Yes,
day.
Lordship.
He is no longer in custody.
No, Lordship.
So today, what is the release you are seeking in this writ
Lordship,
petition?
the affidavit that has been filed by the respondent number 6, certain new facts have come in. So I have,
That's not the answer to the
Yes.
question. What is the relief you are seeking in this writ petition?
Lordship, although we are at that particular point of time, we were seeking
That
protection.
you have said, today,
Lordship,
this
and
particular time, what do you want?
I am seeking by criminal proceeding against the person, number 5 and 6. Lordship.
Law institute it, lodge an FIR.
Lordship.
What can we do about it in writ court? Yes, you are right.
Lordship.
If you think some policemen are involved in taking law in their hands, lodge an FIR.
And also, Lordship, the respondent number 5 being a government servant and he's being a decorated police service, Lordship. He should be prosecuted, Lordship. Respondent
So
number 5
then you have to do it in accordance with law.
Lordship, may
Writ
I,
court cannot prosecute.
Lordship, may I pray to take the matter up after 2-3 days?
No,
By
no,
the
no,
time,
we-
by the
we'll
time.
we'll take it after half an hour. You ask your senior.
No,
we'll
no,
close
Lordship, I'm arguing mercy, Lordship. Lordship,
We'll close it and we'll give you liberty to pursue appropriate remedy. We cannot do anything in this case. You must understand this. It is not a case where we have to direct the police. This will require factual inquiry.
Lordship.
What you are saying, it is an allegation of breach of law, taking law in hands.
Yes, Lordship.
So that cannot be acted upon unless an FIR is lodged. You have to lodge an FIR. Once the FIR is lodged, if the law doesn't take its course, then you come to us, we'll see.
Lordship,
What else can we do today? We
Lordship,
can't prosecute, we can't hold a trial in a writ petition.
agreed, Lordship. Lordship, may take it on Thursday. By the time the affidavit will be on record, Lordship. On Thursday, Lordship.
You are again and again talking about affidavit. What is the affidavit?
Certain facts have come in their affidavit, Lordship.
So tell us what is the fact? and how
Lordship,
it is-
while the petitioners were in custody on that particular point of time, on 22nd 11/2021, the affidavit and the agreement which were forcefully executed by them, that has been notarized, Lordship. And meaning thereby, Lordship, at that particular point of time, the petitioners were not present before the notary, Lordship.
All right, so we'll dispose it of day after tomorrow. In the meantime, you do whatever you want to
Lordship,
do.
I'm filing
But
the
the fact of the matter is, there is no relief that
Lordship,
can be granted.
always
We'll
I'm-
close it day after tomorrow.
Lordship.
On the prayer of Mr. D. Das, learned counsel for the petitioner, let this matter be listed again day after tomorrow as a fixed item by taking the affidavit,
Affidavit in reply that we have filed today.
affidavit in reply filed by the petitioner today, that is
Lord.
give the date. Mr. Your name, please?
ST Adnan,
Mr. SK?
ST Adnan, appearing for respondent number 6,
Mr. SK Adhan.
ST Adnan.
Adnan
Yes,
ST Adnan.
is present on behalf of the respondent number 6, who submits that. An affidavit in opposition on behalf of his client has already been filed. None has appeared for the other respondents.
I'm the patient.
Sorry? Okay. Mr. H. Bejbarua is present on behalf of respondent number 5. The other respondents are not represented.
May I please lordship? Lordship is appeal against the judgment dated 18/8/2022, my lord, by learned session judge Kokrajhar in case number so and so, my lord, by sentencing the appellant to undergo rigorous imprisonment for life and to pay fine rupees 5,000, and in default of payment thereof to suffer rigorous imprisonment for further period of 6 months, my lord. So, matter may be admitted and LCR may be confirmed, my lord.
You are appearing as legal aid counsel.
Yes, my lord.
Heard Mr. S. Datta, learned legal aid counsel appearing for the appellant. Stop. This appeal from jail is preferred against the judgment dated 18/8/2022 passed by the learned session judge, Kokrajhar, in connection with sessions case number T1 oblique 55 oblique 2019, convicting the appellant under section
302.
302 of the IPC and sentencing him to undergo rigorous imprisonment for life and also to pay a fine of rupees 5,000 with default stipulation. Stop. We peruse the interim judgment. Admit the appeal. Call for the LCR. Issue notice returnable in 6 weeks. Since Ms. M. Chakraborty, learned counsel, assisting Ms. B. Bhuya, learned senior counsel and APP Assam has appeared and accepted notice on behalf of the state oblique respondent number 1. No formal notice is required to be sent to the said respondent. What about informant is a
Not
party?
necessary.
Not
part.
necessary.
Informant just acquaintance.
Since the informant is not related to the victim's family, requirement of issuing notice to the informant in this case stands dispensed with.
Not related.
Registry to list the case after receipt of LCR.
Lordship, I'm told,
The informant was the mother of the victim. Madam.
but it
Well,
is-
this is-
doesn't reflect in the judgment of the
Then you're
But
right.
she was not examined.
Then you're right, registry to examine as to whether
Yes.
the
Well.
informant in this case is a member of the victim's
Yes.
family, and if so, steps be taken for service of notice upon the said informant by making this said informant stop. Let the matter be listed accordingly.
Obliged.
Said Nalaga to the informant, said informant.
Item 3.
We have reviewed. Under appeal against conviction, my lord. Under section 366A.
As well
6
as
years,
POCSO.
and under section 4 of POCSO Act, man, 15 years, man. My lord, this may be admitted and it may be called for, man.
Take down. Heard Mr. R. Ali, learned counsel appearing for the. You are not in
My
the,
lord, I am playing one game, HOD, my lord. Not mine.
where is HOD?
HOD,
Gone for a picnic?
well, on behalf of my lord.
Mr. H. Chaudhary, learned counsel for the appellant. This appeal is directed against the judgment dated 1/12/2022, passed by the Court of Special Judge Bracket Poxo Bracket Pros Baksa in connection with Special Bracket Poxo Bracket Plus case number 06/2019, whereby the appellant has been convicted under section 366 of the IPC, read with section 4 of the POXO Act, 2012. Stop. For the offence committed under section 366 of IPC, the appellant has been sentenced to undergo rigorous imprisonment for 6 years and to pay fine of rupees 5,000 with default stipulation,
5,000.
with default stipulation. Stop. For the offence committed under section 4 of the POXO Act, the appellant has been sentenced to rigorous imprisonment for 15 years and to pay fine of rupees 20,000 with default stipulation. Stop. We have perused the impugned judgment. Also heard submissions made by Ms. S. Jahan, learned APP Assam, appearing for this state. Stop. Admit the appeal, call for the LCR, issue notice returnable in 6 weeks. Since Ms. Jahan has appeared and accepted notice on behalf of the state oblique respondent number 1, no formal notice is required to be sent to the said respondent. Stop.
My lord, there is one IA, my lord. Fortune.
Notice be however sent to the, it should go to the victim or informant.
The informant is the father, so let it go to the father
To
then.
the informant who is the father of the victim. Stop. And in the, where is the IA? What is that?
IA, my lord.
Actually, the conviction under both the sections was not required. Under
Yeah, but in
section.
any case, that doesn't help him
No,
because
yes,
practically it doesn't make any difference.
concurrently, so nothing.
Section 4 will prevail if the case is made out.
But in case of wrong sentencing, I'll have to take out judgments. Wrong sentencing, what will happen? Needs to be seen.
All right, you will file,
Objection.
how much time you want?
2 weeks.
Had Mr. H. Chaudhary, learned counsel for the applicant, also had Ms. S. Jain, learned deputy Asaf, who prays for and is granted 2 weeks time to file objection. Let the matter be listed accordingly.
I will be dismissed after receipt of the answer.
I'll file my objection.
I'm obliged to report.
Paper book is ready. Yes. Service.
I
to-
received the paper has been received.
Service. to- Service. to substitute.
No, I think everything we got received last year.
Hmm.
And then the answer like that.
Wow. Service. also.
So otherwise it is ready for hearing.
But it's a POXO matter. The informant side is not here.
Then what to do? Should we engage a legal aid counsel?
It was my duty to check. I didn't check whether the notice was served.
We'll do that for you today.
I'm obliged.
You have done a lot for us. We'll do it for you.
They're obliged.
So it says that service of notice will not be obligatory. There is an order of this court. 4/3/2022. Which is based on
22.
28 to 22 office note.
Acha. Otherwise, the victim is the informant here. Huh? Victim is herself the informant here.
This is very confusing.
Notification to call. Okay. Comment. Quiz bar. Not obligated.
So victim is the informant.
Victim is.
It's a POXO matter.
Yes, ma'am.
Then why did it say it's not necessary and this court has also?
Lordship, because the earlier notification of this court was there 21/12/2021.
Hmm.
So that says it's not obligatory. So Lordship, in that event of the matter, perhaps Lordship has the order. Now the law has come, your Lordship, Jagbir Singh matter has come.
That is on what date?
Subsequently.
The
Yes.
judgment was of which date? I forgot.
Then now notice has to go then. POXO matters, the victim has to be, is that the law?
Yes.
That's the law now because of Jasbir.
What is the
Supreme Court
citation?
judgments. 22, it will say. April 22.
Mr. Datta, you have the citation?
No,
I
madam.
have got this petition.
April 2000. May 22. May 2020. No.
So it is Jasbir Singh versus
Huh.
Jasbir Singh versus
Jagjit
Singh. Jagjit Singh.
It is Jagjit, no? Yes, Jagjit, Jagjit, Jagjit Singh, that was, yes, April 22.
Jagjit Singh versus
Versus Ashish Mishra. Ashish Mishra, 2000. AIR citation আছে, AIR SC 22, 1918 নাকি? 1918.
191.
20 AIR 22 SC 1918.
SCC citation.
SC citation to me. It is, the judgment was dated 18th of April 22. Victim has to be served, yes.
in the appellate stage also.
In all this, from the bail to the appellate, yes.
All right, Mr. M. Datta, learned amicus curiae is present on behalf of the appellant. In terms of our order dated 7/12/2022, a copy of the paper book has been served by the registry upon the learned amicus curiae. However, we find that no notice in this case was issued to the victim, although the conviction is under the provisions of POCSO Act 2012. That was primarily in view of the notification, in view of the amendments made to the rules, to the Guwahati High Court rules, and the subsequent notification dated 21/12/2021 issued by the registry, dispensing with the requirement of service of such notice, full stop. However, it has been pointed out at the bar that since the decision of Jagjit JAG Singh versus Ashish Mishra, bracket AIR 22 SC 1918, it has now become mandatory to serve notice upon the victim in all cases coming within the suit of POCSO Act 2012. First step. Situated thus, we are left with no option but to direct that notice be served upon the victim, in this case, who is also the informant, full stop. Registry to do the needful. Let the matter be listed after service of notice upon the victim. Support given Ms. S. Jahan, learned APPS is present on the list.
Item 5.
This is an appeal against acquittal filed by the state of Assam. There is a delay petition also, and the leave application is also before your lordship. There is a delay of 53 days. Now, the fact of the case is the learned special judge had held that manipulating the body of the victim, like putting oil on the private part, is not a sexual assault under Section 3. But under Section 3, he did not see that manipulation is there in Section 3 itself. So that putting oil and all comes within the purview of Section 3, and it will lead to it will be included in the definition of sexual assault. That is how he had acquitted the respondent.
So we will have to issue notice.
53 days delay. And
That's right.
reasons I have stated in paragraph 8
Hmm.
that initially the PP, Special Public Prosecutor, has written to the government, the entire procedure was undertaken. But after that, COVID-19 regulation, because the judgment was of November 21.
That's fine, but notice has to be issued.
Yes,
Delay can't be condoned without,
because it's an appeal against acquittal.
yes. So notice must go in the delay condonation first.
Leave will be taken later then.
Yes. Give the delay condonation letter. What is the IA number?
838.
38.
838. I.
take down, heard Ms. S. Jahan, APP Assam appearing for the applicant. This IA has been filed under section 5 of the Constitution Act 1963. With a prayer to condone the delay of 53 days in preferring the connected appeal against judgment and order of acquittal passed by the learned special judge Kumar Golaghat in special bracket POCSO bracket close case number 54 of 2019. We have perused the grounds taken in the application, stop issue notice returnable in 6 weeks. Applicant to take steps for service of notice upon the sole respondent by registered post to AD. As well as usual process, first approval. We'll also give you liberty to serve through the concerned.
Police station.
In addition, the applicant's state is also granted liberty to serve the respondent through the concerned police station.
Lodge.
Item number 6.
I know paper book already received my book. May I please, my lord, one IA has been filed, my lord, IA number 794/2022 for impleading party respondents, my lord, the mother of the my lord victim.
You have turned into a, you have not filed it under
My lord,
order 10 or something like that, no? Why not? Order 10 is applicable or not?
yes.
Hmm?
Now, my lord, since the informant is not interested
Hmm.
and he is, my lord, having some nexus with the my lord accused person. So, my lord, we are compelled to file this petition seeking, my lord, permission to, my lord, assist the court in the, my lord, proceeding.
No, that's all right, but unless you show us under which proceeding, which provision of law it is permissible, we will also be compelled to dismiss it.
Then in that case, my lord, let it be listed next week, my lord, we'll show the, my lord, provision.
Achha, today you did not expect
Today, my
it.
lord, we have not.
Why?
Because, my lord, we'll, my lord, apprise the court, my lord, regarding the authority, my lord, under the, my lord, court, my lord.
That you have not seen now.
We have seen that is not available with us at this moment. my lord.
All right. There is no such provision and we'll dismiss it. You choose the date of dismissal. When do you want your IA to be dismissed?
Now, any date, my lord, in the next week, my lord, will satisfy this court, my lord.
Next
Next week,
week?
there are only 2 days, one day.
This is not possible. I heard Mr. Ayat Talukdar and council appellant to submit that.
Yeah, I'm doing to my lord.
His appeal has already been admitted and the paper book is also ready and furnished to him. So therefore, the matter can be taken up for hearing. Full stop. Ms. S. Jahan, learned APP Assam is present on behalf of the state and confirms the said position. Full stop. Mr. M.U. Mondal, learned counsel, has appeared for the applicant in the connected IA and submits that his client be impleaded as party to this proceeding. Full stop. Mr. Mondal could, however, not point out before this court as to under which provision of law such an application is maintainable. Full stop. Be that as it may, on the request of Mr. Mondal, let this matter be listed again on 25th of January 2023, so as to enable the learned counsel to address this court on the aforesaid law point. You cannot get impleaded, but you can assist, file an application to assist the people.
Yes,
The copy may be served to him.
yes.
In the meantime, copy of the IA be furnished to Mr. Talukdar.
Developers.
Item 7.
And this has come up for bail consideration. Lordship had earlier at least once heard this matter. If your lordship remembers, this is a case from Nagaon. The person was, before his death, he called up a friend of his and said that if something happens to me, the appellant will be responsible. That was at 5 o'clock in the evening on 2nd of November. This friend of the deceased, he had recorded that statement, but he had kept shut. He had not said anything. After 2 days, this deceased body was found near the highway. Then these people had transferred this statement into a CD given to the police. Police had not sent it for FSL. Police had in fact not seized the mobile of the friend who had recorded the statement. And trial court, just on the basis of that statement that this is that called me and said all these things has convicted the present appellant under 302. Now, one thing here I would like to point out, Lordship, the matter is of incidents of 2nd of November. On 3rd of November,
2nd of November, which year?
2021, sorry, 11. On 3rd of November, the present appellant, he was apprehended by police on suspicion. Then he was let go on that same day. So 4th, the body was found. Now from 2nd to 4th, there is nothing on record where the deceased was. But when the body was found on 4th, the IO in his evidence has stated that when we found the body, it was fresh. And nothing in the postmortem report, there is time of death or the decomposition of the body or whatever. There's nothing on there. So my only ground in this bail application, the CD or the recording on which the prosecution wants to rely, that has first not been exhibited. IO has stated that I have not sent it for FSL, or I do not know whether it can be tampered or not. So much so, the mobile phone through which the recording was done, IO, the PW5, that is the friend whom the call came, he has said he has transferred that recording via Bluetooth to a computer and made the CD. IO has stated, I do not even know whether that phone has Bluetooth features or not. And the call data records were seized in this case, but they were not exhibited. The additional public prosecutor during the trial said that 65B certificate was not there. But the IO says that from the CD, the call data records were taken out. And in the charge sheet, if you see what all documents were given along with the charge sheet, 3 seizure lists, 2 Jimmanamas, PM and inquest. There's no mention of call data records in the charge sheet. Now, presently, my stand is just that on the basis of a document or on the basis of an evidence which was not even sent for FSL or to verify its authenticity, I was convicted. That is my only ground for bail.
This is a what evidence? Which evidence?
That CD, that phone call.
That's not evidence. It's not
And
admissible.
to supplement that, the brother of the deceased here, his PW4, he has said the call that went.
All right, 1 minute. The deceased had made a call to his brother.
No, a friend, PW5, at 5 o'clock on 2nd November 2011.
Saying that if something happens to him,
appellant is responsible. Just
that's
that.
all.
Just that. He said that, so that then PW5 said, you please repeat what you said. He recorded that thing. That if something happens to me, appellant is responsible. That is 5 PM. PW4, that is the brother of the deceased. He states at around 10 o'clock that same night, the deceased called up and said, I'm coming home. Thereafter, there was no news of the deceased. There was a GD entry on the next day filed by the father, but that was not before the trial. That was not exhibited. That was not brought.
And body was found on 4/11.
4/11 around 10:30 morning near the highway. Now, the earlier GD entry on the basis of which I was apprehended, that is not made part of the record. Father had said that my son is missing from yesterday. That is not on record. He has specifically stated that that has not been brought on record. On the basis of that GD entry, the earlier 3rd November GD entry, I was apprehended. I was picked up by police on suspicion, and I was allowed to go. 4th, the body was found. Incidentally, the IO says in his evidence, when we found the body, it was fresh. So it cannot be that he has died. And the postmortem report, there is nothing about time of death. There's nothing about time of death. So if a body is fresh, there's nothing on time of death or the decomposition or the state of the body. It cannot be assumed that he was killed on 2nd, maybe after 10:30. 10 o'clock, he made a phone call to his brother, said, I'm coming home. And body was found on a public place near the highway. It cannot be that on 3rd, the entire day, the body was lying there and there was nobody who could find it, who could have seen it. 4th, it was the public who has informed, actually made a halla and that the body was there. And these people then when to search for, when to recover it.
Then the applicant was again arrested.
Then he was arrested. On 5th, an the formal FIR was filed. On the basis of that, appellant was arrested. Later on, actually, another 2 persons were arrested. These 2 persons were acquitted by the learned trial court. In fact, Lordship, phone was seized. Phone was same day given back in Zimma. It was not even sent for FSM. Nothing was sent for FSM.
So since when is he in jail?
From date of judgment,
What is the date of judgment?
21/12/21.
Yes.
The only evidence here, the deceased and the applicant were working in a garage. They were co-employees. And then on one fine day, he went for lunch to the garage. Father found that his son didn't come back for long. He went to the garage, asked the other employees, and the employees said that the deceased had not come to the garage that day. And thereafter, father had lodged a missing entry. And on that basis, he was arrested initially. Thereafter, PW5's evidence comes into play. PW5 had recorded the telephonic conversation. He had placed both the phone as well as the recording before the police. Voice was recognized. And thereafter, he was again arrested. So the only evidence is that PW5 4 had called up, PW5 came to know about the fact. Father also had come to know about the fact. The death was due to strangulation. And as far as the call data records are concerned, it was collected, and I have seen the case diary. It was matched also. All phone calls with the deceased and with the PW5 were matched, and it was found the timing and all were also, it was proper. That time there was a call from the victim side. Of course, it was not exhibited. Certificate was not there. In fact, Lordship wanted to take a call from the superintendent as well as the IO. IO had retired now. He's staying somewhere at Tejpur. Of course, there are flaws. But the evidence is that there was a call. And that statement would be relevant under Section 32. If something happens to me, he'll be the one who is responsible. These are, of course, the evidence. Of course, body was found on 4th. And the doctor had said strangulation, time of death was not mentioned. Fresh, I have to check.
PW15.
So if it is fresh, then the death was not on 3rd. 2nd, he went missing. 3rd, perhaps they were together. 4th, something had happened.
We have tried to translate the evidence. Some of them are very illegible. We have tried our best.
Show it to her.
It was doctor's evidence.
Doctors
Doctors will be in English. No? Doctor is PW.
In fact, as of the call data records, my
12.
IO in his cross-examination stated, I did not send the call verification list to the court. I'll take your lordship to the cross part of the IO. Your lordship comes to page 83. PW 15. Page 83 is the cross part. The supplementary CD indicates inquest report was done on 4/11/11 at around 9:10 AM. It was done in presence of witness so-and-so. The names of the family members who identified the dead body are not mentioned. Later on stated that the dead body was identified by Father Hariprasad Sutradhar. He is PW 3. FIR was lodged on 5/11/11. The informant on 3/11/11 lodged a missing entry and same is not sent to the court with CD. Your lordship will mark this because father has said we have not looked for him. The FIR dated 5/11 is the second FIR in connection with this case. Mobile was seized on 5/11/11. Nipen Burman, who's PW 5, himself submitted the compact disc containing the data from the mobile phone, and the same was prepared by him. CD was not sent to FSL for authentication. I did not send the call verification list to the court. It is not stated whether the seized mobile was an ordinary mobile or a smart Android phone. I do not know whether it contained Bluetooth features. Witness Champa Devnath stated before me that the deceased called her over phone and told her he will come to Monoha Mandir at around 8:30 PM. Now that call of alleged dying declaration is at 5 o'clock. Since the compact disc was not sent to FSL, nor it contains any certification, I cannot say whether it is tampered or not. I cannot say whether the video recording was kilobyte, gigabyte, etc. Nipen Burman did not disclose where he converted the data from the phone to the compact disc. PW 5, his Nipen Burman, stated before me that the deceased told him that he was having beer in an isolated place. PW 5, there is no alcohol found in the stomach as per the postmortem report. PW 5 stated before me the brother of Abhijit is the deceased, asked me about the deceased over phone. PW 5 stated before me that he did not tell before police about whereabouts of Abhijit, nor he knows that he did not return home. And today, after coming to know about the recovery of dead body from the bypass, police seized my mobile phone. PW 5 did not state before me that he went to police station twice, and police, after hearing the recording from the mobile phone and returned the phone, nor stated that the deceased told him over phone that he will meet him. I do not know from what distance data can be transferred from one mobile to another via Bluetooth. There is nothing about Bluetooth in my CD. This should be PW 4, did not state before me that my brother works in the same place where Rajiv works as the head. Rajiv is the accused. PW 6 did not state before me that the deceased informed him over phone that he recorded the data from the mobile. PW 8 did not state in statement under 161 that when police seized, the dead body was shown, then accused told that he threw it there. This is PW 8. This is for the other two accused persons who have been acquitted. Statement was recorded on 12/2/2012 at around 1 PM. PW 10 did not state in his statement under 161 CRPC that accused came along with the police to the place of occurrence, that is the other accused persons, and told that they, after consuming liquor, killed the deceased by strangulation. There's another accused, Uttam Ghosh, who has been acquitted. He has stated this. We took him there and strangulated him. It is his statement. So Lordship comes to PW 3. Just one portion I would like to share. Is the father. He's at page 23.
Page 23.
23.
Because of school and all.
Actually, this is a type copy. There may be small mistakes. Actually, the cross part. I do not know whose garage and what garage Abhijit works. First part. Thing is that it is the allegation that accused and deceased used to work together. This is the father. He said, I do not know on whose garage and what garage Abhijit works. Abhijit is the deceased. I do not know whether the garage is a motor garage or a scooter garage or something other. I did not know the accused persons earlier. On the day of incident, after taking lunch, where my son went, I do not have personal knowledge. I lodged the Ezahar at police station as I did not find Abhijit. After lodging the Ezahar, I came to know that my son called Nipen. This is the first Ezahar, or third, which is not on record. I do not know before lodging the Ezahar that my son called Nipen. After taking lunch, where my son went, with whom he went, I do not have personal knowledge. I have lodged an Ezahar that my son did not come home before lodging this instant Ezahar on 3rd November. in the earlier Ejahar, I mentioned that my son was missing, but I did not write in the FIR with whom he went and where he went. I do not know if there was any dispute or fight with the accused persons. I lodged the Ejahar on 5th November and police had written the Ejahar. I had signed. I cannot remember what was written in the Ejahar as I was mentally unstable at that time. Sujit is my other son. He's PW4. He stays with me. Sujit also did not know anything before getting the dead body. But PW4 in his statement says he comes to know earlier only. On 4th only, he comes to know that brother had called up this PW5 saying if something happens to me, the accused is responsible. In his statement, he says that. Then Nipen's house is situated near my house, 150 feet distance from my house. Since Abhijit's missing till finding of his dead body, Nipen did not say anything. Nipen knew that Abhijit did not return on 2nd November. But Nipen says here on the next day, he has told the brother of the deceased, that is Sujit, that such and such phone call has come. Nipen is a carpenter. Nipen did not inform me over phone that what was Abhijit doing, where and with whom was Abhijit. I have 2 other sons, so and so. Biswajit was outside at the home at the time of incident. I did not mention all these things in the Ejahar as Nipen did not inform me anything. We did not inform at night as we do not know the phone number. Earlier also Abhijit used to not return for 1-2 days and hence we did not search for Abhijit on 2nd November, second night. Abhijit's mother used to not return to home for 2-3 days while she went for Nam Kirtan, and as a result, we did not take seriously about not returning of him. At the time of lodging the Ejahar, I did not mention that I suspect anyone. It is true that after Abhijit's dead body was being asked by police, I have stated that someone killed Abhijit, and it is true. I do not know if Abhijit had a friend named Sumit. I have not seen the Ejahar lodged on 3rd November in the record. After lodging the Ejahar, I came to know that Abhijit called Nipen. I do not know if police had mentioned in the Ejahar that Abhijit had called Nipen. It is not a fact. Nipen did not call me. Now, there are very many contradictions on the timeline.
Yeah, where is the judgment? Is it a part of this paper?
No, madam, it's a part of the appeal memo.
Let us see the appeal memo.
The judgment starts at page 20.
Yeah, let us take us to the conclusions. Analysis and conclusions. Which page?
My lord, page 27, first part. Paragraph 21. I may point out that tape recording and playing of tape recorded message has always been considered relevant for the purpose of adjudication of civil or criminal in India. The value and weightage to be assigned to such tape recording will, however, depend on various factors, including authenticity of the voice, tampering or non-tampering of recording, etc. 22. What, however, needs some emphasis in the instant case is that even deholds the tape recorded message, Nipan Burman has deposed on oath as an oral witness and he has been cross-examined. His oral testimony is substantive evidence and has its own weightage independent of the tape recorded message. So based on this entire case on me has been formulated.
And on what basis the other 2 accused persons were roped in?
There was
They were
one.
in the garage, no, they are
They
the
worked
workers.
together in
They
the garage.
workers in the garage.
Just Mr. Uttam Ghosh, who was acquitted, he was taken into custody after 3 months. 3 months of the incident. Even he was taken to the place of occurrence. And there he has stated that after having beer, he had strangulated the accused, deceased, and the other 2 accused, that is me and another person, were present there. It is not that we have together strangulated, but it was stated that all these things were said before the police while being in police custody. There was nothing substantive against those 2 persons, so they were let off on benefit of doubt. But against me, this Nipen Burman saying, Mr. deceased called me, but the timeline, 5 o'clock deceased calls, PW4 states, 10:30 same night, he calls up his mother and says, I'm coming home. That is on 2nd November.
Mother or brother?
Mother, he calls up mother. Brother says, he calls up the mother and saying that he's told mother that I'm coming home. That is PW4. PW4 states there. Third, accused, the present appellant was apprehended on the basis of suspicion. Then he was allowed to go. Body was found on 4th near the highway. It's a public place. So the probability that the body was lying there on 3rd without anybody noticing it becomes invariable. Secondly, the IO in his evidence says when he found the body, it was fresh. PW14 is the earlier IO who had recovered the body. In his cross-examination, he says that.
What is the extrajudicial confession here?
No, that was before the police,
In
no,
police custody.
it was before the police, it did not come
Where
out
is the
in yet.
discovery leading to discovery? See page 32, the summing up by the learned trial court.
Where is no 27 it is.
Extrajudicial confession in police custody has been taken note of.
By the Uttam Ghosh, my lord, as I said, the other
He is the
accused who was taken to
co-accused.
the place of offense.
Extrajudicial confession by Uttam Ghosh. Now he is the co-accused, he has been let off. And this is extrajudicial confession before the police. This will not be an extrajudicial confession because by that time he was under the surveillance of the police.
So this
This
is
will
what.
not go.
Next is, where is the leading to discovery? What was,
Leading to discovery of the fact that accused has knowledge of the place where the dead body was thrown.
which accused?
Perhaps the applicant, now lordship, I'll just see, the police did not say about the discovery part. It was lying on the road and it was found out by the public.
So the trial court has summed up the prosecution case on
Yes.
these two parameters, which are, according to us,
Police took Uttam Ghosh to the spot. It is not the applicant. After about 2 months of the recovery of the body, by that time it must have been in public domain as to where the dead body was found. Moreover, the procedure adopted in stopping the car near the place and quizzing the accused is not what is expected.
so that's not leading to.
Yes, this is not leading to
discovery. What
discovery.
else is there?
The only evidence is that phone call,
That to oral evidence,
32, oral,
nothing else.
and the other circumstances. Working together, he said what garage, whose garage, he doesn't know, but then they used to work in the same garage. So there's companionship, they were together, and then he was missing. Thereafter, police had filed the missing
Too
report.
tenuous to hold back someone.
Case, call data records are there on the case diary, lordship can see. But sometimes there are cases even non-exhibiting of few documents. If it is very important in the case, can be taken note of.
But consider yourself lucky that this appeal has not been listed for hearing today.
Yes,
So you take your seat.
lordship.
Yes, take one. Administrator D.K. Bhattacharya, Learned Counsel, appearing for the applicant. Also heard Ms. S. Jahan, Learned Deputy Assam, appearing for this state. The applicant was convicted by judgment dated 21/12/2021, passed by the
Additional
Additional District and Sessions Judge number 2, Nagaon, in connection with sessions case number 51, bracket capital N, bracket close, oblique 2014. And by order dated 23/12/2021. No, passed in connection with so and so for committing the murder of deceased Abhijit Sutradhar. And by order dated 23/12/2021, he was sentenced to undergo rigorous imprisonment for life and also to pay a fine of
20,000.
20,000 with default stipulation. Full stop. Aggrieved by the judgment and order of conviction, the applicant has preferred criminal appeal number 118/2022, which is pending disposal before this court. Full stop. The instant IA has been filed under section 389 bracket 1 bracket close of the CRPC with a prayer for suspension of jail sentence and also for releasing the suspension of sentence and also for releasing the applicant on bail during the pendency of the appeal. Full stop. By referring to the materials available on record, Mr. D.K. Bhattacharya, learned counsel for the applicant, submits that the prosecution of the applicant is entirely based on the testimonies of PW's 3, 4, and 5.
3, 4, 5.
But their
Father
evidence is
or
full of
brother?
material contradiction. Full stop. According to Mr. Bhattacharya, the sole basis of conviction, which is the alleged, which is the telephonic conversation between the deceased and the PW5, which was allegedly recorded in the mobile phone of PW5 and subsequently transferred into a CD, was neither sent for FSL nor was it produced as evidence in accordance with law. Full stop. Moreover, submits Mr. Bhattacharya, even the CDR was not adduced in evidence by the prosecution side. Under the circumstances, it is a clear case where there is not even an iota of evidence to sustain the charge brought against the applicant. Full stop. Mr. Bhattacharya has further argued that the co-accused persons had been, the two co-accused persons had been acquitted by the learned trial court based on the same evidence, and therefore there was no valid basis to convict the applicant in this case for committing the murder of the deceased. Full stop. Next paragraph. Responding to the above, Ms. S. Jahan, learned APP Assam, has taken us through the impugned judgment as well as the objection taken by the state to submit that even if the CDR was not adduced in evidence and the telephonic conversation was not produced in accordance with law, not produced by the prosecution in accordance with law, yet the oral testimony of PW5 has been taken note of, and therefore there is some evidence to convict the applicant. Full stop. Whether the evidence is sufficient in the ultimate analysis, would, however, submits Ms. Jahan, have to be examined at the stage of final hearing of the appeal. Stop. We have perused the materials placed on record and have also considered the arguments made by learned counsel from both the sides. Full stop. We find that apart from the testimony of PW5, who had allegedly recorded the telephonic conversation of the victim, bracket deceased, informing him that if something happened to him, bracket again victim, then the applicant will be responsible. There is no other direct evidence to implicate the applicant. Full stop. The telephonic conversation recorded in electronic form has not been produced by the prosecution before the court, nor has the CDR been adduced in evidence. Full stop. We also find that the learned trial court had taken note of extrajudicial confession made by one of the co-accused person during the course of investigation and while he was in police custody, which was evidently inadmissible in the eye of law. First of all, even the conclusion as to leading to discovery by one of the co-accused does not appear to be valid in the eye of law. First of all, we agree with the submission of Ms. Jahan that whether the evidence adduced by the prosecution is sufficient to sustain the conviction of the applicant under section 302 of the IPC is a matter which will require minute scrutiny of this court at the time of the hearing of the appeal. However, in view of the reasons indicated above and considering the materials available on record, we are of the opinion that the applicant has made out a strong prima facie case to allow him to go on bail during the pendency of the appeal. We accordingly direct that the applicant so-and-so be released on bail on furnishing a bond of ₹30,000 and one local surety of like amount to the satisfaction of the learned trial court. It will also be open for the learned trial court to impose any other additional condition for releasing the applicant on bail if so desired. We, however, make it clear that the observations made herein above are purely for the purpose of disposing of the bail application, and the same shall not have any bearing at the time of the hearing of this appeal. The highest funds disposed of. Yes. These are all botched up investigations.
Lordship.
Main appeal paper book may be directed.
Yes, but you must say thank you to the IO.
Yes, otherwise.
Say thank you. Send him some goodies also. during-
Only on the basis of telephonic call without any.
The IO
very
doesn't know
difficult.
how to conduct investigation. The prosecution doesn't know how to conduct prosecution. So it's sheer providence that some criminals are punished. It's just providence. It's not the state.
Even
God plays
65
some role and it is. Otherwise,
even-
this is all lottery going on.
Even 65B had come into force long back, but they have not followed, they have not taken. it.
65B, you're talking about IO.
Yes, they will not.
Find out who all are aware of 65B.
Hmm.
Yes.
Obliged.
Forget who all are aware about 65B. Many seniors don't even know what is the real purport of 65.
Yes.
When you are producing the electronic version,
Hmm.
then somebody who is conversant with the electronic aspect of the matter has to give a certificate
Hmm.
that this is either the printout or copy of
Yes.
this material.
Output, yes.
That's all.
Hmm.
If that is not given,
Hmm.
then the court will not be
Will not be satisfied with simply.
satisfied with it and therefore will not accept it as evidence.
Hmm.
That's all.
That's it.
But this is being twisted this way, that way. But then this is how it happens. It is for the appellate's court to
See,
correct,
otherwise-
but then they don't take note of it.
Hmm.
The departments don't act on this. They will just pass it on as another judgment. All right.
Hope
All right.
so,
Okay.
something better happens.
Yes. 8 and 9, what is it?
May it please, Your Lordship. I am before you against the suspension of sentence pronounced by the Linet Court below on 12/1/2022. Conviction. On the
Conviction is under which provision?
302, my lord. Along with co-accused Hafiz Rahman, sentenced to be undergo imprisonment for life and to pay ₹10,000 only each in default to undergo simple imprisonment for another period of 3 months. My lord, appeal has already been admitted. And Your Lordship may.
It is a
grant this
case of
I-
what? Direct evidence or circumstantial?
Circumstance. My lord.
What is your ground?
My lord, My ground is more summarily described in the IA, my lord, that is, last page, paper book, my lord. Para 3 is more particular, my lord. May I read, my lord?
You're referring to your IA.
My lord. IA to asset Raji. Four,
The
five.
paper book and IA, these are two different things. Which are you referring to? You know there is a difference between paper book and
My
IA.
lord, paper, in the paper book, 451 IA is there, my lord.
Take it. Give it to her.
I am my lord, I 451. I will give it.
Yes.
My lord. Para 3, my lord, that appellant as preferred criminal appeal by challenging the aforesaid judgment and order dated 12.
All right, these are, you're reading from your IA. What is your case? Tell us.
My lord, my case is my lord, I am nowhere related with the murder, my lord. I was there along with a baby in my lap, my lord. And the deceased is my husband, my lord. So, my lord, and there is no eyewitness. And and I have a small baby, my lord, who is around 4 years old, and I am behind the bar since 1 year, my lord, about to 1 year.
No, but that's not the way to argue a IA for bail. You have to argue it the way it has to be argued. I am innocent, please let me go. This is not the argument of a counsel. This is how the family members will come and argue. What is the case on which you are seeking bail?
Memo of appeal, my lord, and your lordship, my ground may be memo of appeal, my lord.
What is her case? Can you argue for her? She's not the-
Lordship, actually, this accused persons were last seen with the deceased. Deceased, they left the dead body, into the place of PW1 and they left. There's no explanation. Apart from that, I did not find any ground for conviction, my lord. Lordship, records might reveal something else, my lord. I have not gone through the LCR, but mere reading of the judgment, your lordship, one with Jaheda and other was Hafizur Rahman, they were found seen behind the dead body, your lordship. And at that time, some witnesses say
The
that
dead body was found where?
in the
In
residence
the
of
informant,
PW1,
PW1, my lord.
PW1, the residence of PW1 informant.
Who is the informant? How is he related?
PW1 is one lordship, Homek Khan, my lord. That's evidence to go through. And I don't find anything else, my lord, in the entire evidence.
3, 4.
They were seen together with the dead body.
Yes. And she is the wife of the deceased.
Hmm.
She is the wife of the deceased.
And what about the other person?
Other person, Hafizur, my lord, relationship, my lord.
You are appearing for the other person. He is also convicted. He is in jail.
Yes, yes. This. Hafizur, submitted as a Hafizur.
Hmm?
No, apart from last scene, I did not find anything, man. Apart from last
No,
scene
but they
theory.
said they were seen with the dead body. That's
Yes.
not last scene.
They were there with the dead body, and,
That is
and
not
some
last-
witnesses have said that Lordship, yes, he was alive. The dead body, when these persons were there, that dead body was not, the body was not dead in dead
Dead body
condition.
was alive.
Not dead, my lord.
Person was not dead, your Lordship. He was alive. Some
Actually, my
witnesses
lord,
have
he
said.
consumed some liquor and Hafizur.
And evidences are not clear, my lord. I have gone through the judgment, but I have not gone through the evidence on record, your lordship. From the LC, I have not seen, but from the Jasmine, I have made this an objection, madam. But I don't find anything else. Lordship, let the paper book be ready, your Lordship, let the matter be taken up.
No, they are asking for bail. We
Bail,
can't
no.
push it like that.
Lordship, then I don't
There is nothing
find.
to sustain the conviction, then why should they be on?
That's true. That's true, your Lordship.
Let us see the. Paper book is already there.
I don't know the paper. For Hafizur, my learned friend has prepared this an objection. Extramated objection. And they had illicit relationship, these two accused persons, my lord.
My lord,
That's
that's
what
not true,
evidence.
my lord. That is only the same one.
Lordship, pair of 50 of the judgment.
Just 1 minute.
Yes.
So is it a homicidal death?
Yes.
What does the postmortem say?
Postmortem strangulation. Rope was also found.
Hmm? Which page is the PM?
Lordship PW4, I don't have the paper book. PW4 is the doctor. Ligature mark partially innervating the name trespassing.
Sorry?
Start from my page number 78 and the bottom page number page number 51.
Asphyxia as a result of strangulation. Homicidal antemortem in nature.
So, only testimony is PW1.
Informant,
Hmm.
yes.
There's no other evidence.
I don't find, your lordship. I may be wrong. I didn't find.
And was there any explanation from them?
Actually, I don't know. Yes, actually. It's a good thing.
You don't have the paper book.
I don't have.
No, we'll take it up tomorrow then. You go through the paper book.
Lordship,
Tomorrow?
copy be provided to me. I don't know. Day after then, madam.
Are you there day after tomorrow?
I
You are available? We'll take
get
it
a
up.
Xerox from the court, ma'am.
You ensure one. Let's see if there is nothing, then why
Yes.
should they be held up?
Yes.
But then the testimony doesn't appear to be very correctly written.
Yes.
So it requires a little
Yes.
minute observations. We'll have it day after tomorrow. Heard Miss
BD
so-
Sharma.
for the applicant and so and Mr. J. Aloy for the applicant and so on. Also heard the learned APP Assam appearing for the state in both these cases on the request of Ms. B. Bhuya, learned APP Assam appearing for the state. These matters are directed to be posted again day after tomorrow as fixed item. In the meantime, office to furnish copy of the paper book to the learned APP. You go through it and if there is nothing,
Okay.
then we'll allow them to go on bail.
Item 10.
The delay condonation application, delay of 45 days. Appellant was convicted under 376(3) and section 4 of POCSO. Last time notices were, steps were taken on respondent number 2. But the office note says that it has answered notice, neither ID card has come back. Office note dated 15/12.
So appeal against judgment of conviction.
Judgment of conviction.
We'll condone the delay then.
Lordship.
All right. I heard Mr. D.K. Varadarajan, learned counsel for the applicant, also heard Ms. B. Bhuya, learned senior counsel, bracket APP Assam, bracket assisted by Ms. M. Chakravarti, appearing for the state oblique respondent number 1. Post of. None is appeared for the respondent number 2. Post of. This IA has been filed under section 5 of the Limited Act, 1963, praying for condoning the delay of 45 days in preferring the connected appeal against judgment and order of conviction. We have perused the grounds stated in the IA explaining the delay. First of Ms. Bhuya summoned that there is no instruction to file objection on behalf of the state. First of, considering the explanation furnished by the applicant and in view of the fact that the appeal is against the judgment and order of conviction, whereby the applicant is presently serving jail sentence, we do not deem it necessary to defer the consideration of this IA any further, only on the ground of service of notice upon the informant. The explanation for delay furnished by the applicant is found to be acceptable and is found to be reasonable and is hereby accepted. The delay of 45 days stands condoned. Office to register the connected appeal in list for admission hearing. IA stands disposed.
Obliged.
Item 11. Oh.
Here one interlocutory application is filed by the mother of the victim to impede herself as respondent number 3, Lordship. Although informant was a party here and informant was not related to the victim, but now the mother of the victim has come.
Lordship, that MU Mondal here also MU Mondal
This implement under which provision?
In my humble answering, Lordship, as per CRPC, there is no provision for impediment. They have a right to participate in the proceeding if the honorable court permits, Lordship.
You can assess the PP. That's all.
Yes. And for the, I have filed the appeal, Lordship, and now Mr. Amiu Mondal has filed the application for impediment, Lordship.
Your filed appeal means
I have filed the appeal against conviction. I am for the appellant.
you are for the appellant.
Yes.
This
Amiu-
IA has been filed by whom?
Mr. Amiu, mother of the victim, Lordship. That is Amiu Mondal for Jasmina Bibi, Lordship.
Lordship, one matter, your Lordship, it's this.
Similar case, not similar case. This is different case.
But they also
Uh,
Mr. MU Mondal.
This IA has been filed with a prayer to impede the applicant in the connected criminal appeal. Full stop. However, the applicant's counsel is not present when the matter is called up. Full stop. Mr. A. Ahmed, learned counsel for the appellant, and Ms. B. Bhuya, learned APP Assam are present. Full stop. Since the applicant's counsel is absent today, let this matter be listed again as a fixed item on 25th of January 2022. 2023.
Hearing list. Item 1, 3, 4, 5, 6, 7, 8.
Item number 7.
And I am appearing as an amicus member.
Radhanath Tade.
I'm very sorry to say, actually, we don't have our paper book. If your lordship insists, I can see the LCR and do the case. But, I don't know, our office people are busy with bail matters also. They have not provided us the paper book today. But I can,
It's a
see
part, we'll take it up tomorrow then.
tomorrow, I'll fix up everything.
We'll go through the paper book.
Lodge.
The case of, it's a 302
302.
eyewitness.
No, it's a case of circumstantial evidence.
All right. So anybody else ready with final hearing matter?